We are going to move to our fourth panel, which, as you can see, will examine emerging issues in the regulation of carbon dioxide removal. And I'm pleased to moderate this panel. I'm Will Burns, the co-director of the Institute for Carbon Removal Law and Policy at American University. I think it's fair to say that as we've moved in the last couple of years in earnest from field research and mesocosm research or lab research and mesocosm research to field research and full-scale deployment of carbon removal approaches, the role of law in terms of regulating these approaches to protect the interests of all stakeholders, as well as to provide assurances to those that may be investing in this sector, has become paramount. I think it's also fair to say, as I said at the outset, that there remain lots of abiding issues in terms of regulation of CDR. Many of the statutes that are being called upon to bear the weight of regulation for CDR may not be fit for purpose. They certainly didn't contemplate, in many cases, approaches of this nature, and it leads us to need to focus on how to make those provisions fit for purpose, or to expand the ambit of regulatory purview in a way that ensures rational development of the industry while protecting the interests of everyone concerned. And so that is the focus of this panel, is some suggestions of abiding issues, both at the international level and the national level, when it comes to the law, and suggestions of ways to move forward. And so what I'm going to do initially is I'm going to ask each one of the speakers just to briefly introduce themselves, and then we will turn the floor over initially to Cymie Payne. So I'm going to ask Cymie initially to introduce herself.
Hi, thank you for the invitation. I am Cymie Payne. I'm speaking in my capacity as a scholar and member of the Rutgers University faculty. I also do a lot of work with the International Union for Conservation of Nature. I chair the Ocean Law Specialist Group there, but IUCN does not currently have a formal position on CDR. That is something we will be formulating soon.
Thank you, Cymie. Korey?
Hi, everyone. I'm Korey Silverman-Roati, and I am a senior fellow in carbon management and negative emissions at the Sabin Center for Climate Change Law at Columbia University.
Thanks, Korey. Ben?
Hey, it's great to see everybody here, and thank you so much, Will, on the Institute for Carbon Removal Law and Policy for organizing this great conference today. I'm Ben Rubin. I'm the Executive Director of the Carbon Business Council. We're a nonprofit trade association with more than 100 carbon management companies. So we'll be speaking during the session about some of the regulatory challenges and opportunities that companies are facing as they commercialize and scale carbon removal.
Thank you, Ben. And finally, Christian.
Yeah, good evening, everybody from Northern Germany. I'm based at Kiel University. I'm a professor for climate ethics, sustainability, and global justice. I'm here located at the Department of Philosophy. I do have a background in environmental science, but that's quite a while ago. And so in philosophy since more than a decade. And also, I guess my kind of contribution will also kind of show that a little bit, but we come to that later. So looking forward to the panel.
All right. Thank you, Christian. Okay, the way we'll proceed is we'll have initial interventions by all of the respective speakers, and I would encourage everybody to start populating the Q&A box with questions, and then we'll proceed in the latter portion of the session with those questions. And so with that, I will turn over the microphone to Cymie.
Okay, thank you. I will share my screen. And we'll hope that after what feels like a lifetime of doing this stuff, it'll work. Yay. Okay. And you can see it, I take it. Yes, we're good. Okay. So I'm going to discuss legally binding international agreements that are equally important for their regulatory role and their ability to create institutions and processes that can help us attain our objectives of safe management of Earth systems. So I don't want us to be thinking about international treaties as just regulatory, okay? Because sometimes these other functions, in fact, probably usually these other functions are even more important. So I'd like to start out by framing the context for considering international treaties, then look at the leading treaty regimes that are relevant to carbon capture in the marine environment. And I'm not going to do justice to the ones that we're most familiar with because I'd have to talk extremely fast to give them the time they deserve. So then I'll turn to the newest treaty in town, which is the High Seas Biodiversity Treaty, and highlight what it promises to contribute to CDR research and potentially eventual deployment. One thing that is also important to say, because a lot of the discussion today has focused on both terrestrial and marine CDR, I'm going to be just focusing on marine, okay? Ocean is 70% of the planet's surface. All that blue area, light and dark, is ocean. And especially in areas beyond national jurisdiction, that's the light blue areas that are, for the most part, more than 200 miles from shore. That is the particular focus of the High Seas Biodiversity Treaty. Okay, and it's 2/3 of the ocean, and it's where these creatures live. And I'm going to leave them on for a little bit before I go back to regular PowerPoint. So the current situation is we have public and private interest in research into marine CDR and its future deployment. The ocean is suitable for many of these technologies, and it comprises over half the surface of the planet. So in theory, it's a place that we can scale up to the amount of carbon that needs to be removed. There appear to be fewer competing activities and interests than with terrestrial sites. We've already heard a good bit about those problems, especially from the keynote speaker. However, I'm hoping that these images, these videos from the deep ocean, will convince you or start to convince you that that's not entirely true, that we have enormous human interests in the functioning of these ecosystems, and that there is incredible variety and density of life in those ecosystems that needs to be accounted for. However, there's also less scrutiny, and the social norms that we have towards this ecosystem are less protective than in coastal and nearshore areas. That implies greater risk. So Priya Prasad asked, does it matter if we have a uniform global framework? And I'm willing to be convinced by her presentation for the points that she was presenting, maybe not. However, would a uniform global framework, a legally binding framework, help us with some of these objectives? The ocean, it is a natural carbon sink. It's the most important one we have. That is through biophysical processes. It's not like, oh, the carbon dioxide just gets absorbed into the water. It happens partly through the mediation of biodiversity. And we're just beginning to understand that and to understand that we need to protect it. Marine environment is subject to the triple planetary crisis: climate, biodiversity loss, and pollution. So it's doubly or triply vulnerable. And some ecosystems are going to be vulnerable to the effects of even minor impacts of human activities, including some of the technologies that we're discussing here. It depends on the life forms, the activity, and other impacts that cumulatively are affecting that ecosystem. We also need to remember when we're thinking about conservation that ocean ecosystems are highly connected and that transboundary effects are an important consideration both politically and ecologically. Second, it's really important that we do more scientific research. I think we're all agreed on that. And, can an international agreement help us with that goal? We just heard about the importance of including considerations of justice and equity as we move forward. And I think you see that in all of the guidelines and efforts that are being done. And for business, it's important to have a predictable, stable regulatory environment. So what can an international treaty do? An international treaty, and we have many, although they are not a lot for this particular topic specifically, they can provide processes and institutions for governments, civil society, and business to cooperate and coordinate. They can provide rules, agreed upon rules that may be guidelines, they might be legally binding rules to protect and preserve the ocean's biophysical and other function, the carbon sequestration and other marine biodiversity. They can provide a means to develop capacity for developing states to participate fully in science, in the technology, and in the governance. And they can provide an approach to facilitate joint scientific research and legal research, for that matter. They can provide consistent rules across legal systems for global markets. So not part of this talk, but I put a little laundry list there of other things that if we were doing a CDR treaty, we would want to consider. The emissions credit and other financing, the short and long-term ownership of the carbon and of the storage rights, intellectual property rights, confidentiality, liability, many other issues. But I'm not going to go into those issues. As it is, we have a kind of massive number of treaties that do different things. This particular diagram is just mainly it's one that was designed to talk about the High Seas Biodiversity Treaty, but it gives you an idea, and it puts the Convention on Biological Diversity right at the center. So let's see what we've got. Convention on Biological Diversity applies globally. U.S. isn't a party, but most countries are, and the U.S. is an active observer. It's so far, and it got onto CDR early, but so far it's produced just 9 non-binding decisions, specifically recommending that ocean fertilization be avoided pending adequate scientific information on safety, and the implementation of a global, transparent, and effective control and regulatory mechanism. And it makes an exception for small-scale research. Now, I think it's worth flagging that the CBD decision also highlights that scientific research could and should be done, but it should be done according to certain criteria and, quote, not be used for generating and selling carbon offsets or any other commercial purpose. So that's directly at odds with what I understand some of the offset activity may be currently, although maybe it's not happening in the ocean. Another treaty that you're probably pretty familiar with, it's a pair of treaties, the London Convention and its protocol, apply to all marine waters other than internal waters, so to coastal and open ocean. It sits institutionally within another body, the International Maritime Organization. And I'm just going to skip right over the details of what it does. It does some regulation of ocean CDR, but it's very limited. Another regime that has potential to be relevant would be relevant for activities in the Southern Ocean, and that is the Antarctic Treaty Regime. It has institutions, it has a useful membership, it's got various measures that could be applied to CDR there. The UN Convention on the Law of the Sea has a number of measures that fit into what we are desiring, but they haven't been applied explicitly and directly to this kind of issue. And I'm gonna, again, because I want to get right to the BB&J agreement, I'm not going to go through the list of these obligations in the convention, but I will say that the next agreement that I'm going to talk about, this is the new one, incorporates these provisions. Okay, it's debatable whether it's actually technically an implementing agreement to the UN Convention on the Law of the Sea. That's for lawyers, but it's a treaty that you would refer to the Law of the Sea Convention to understand what it means and how to apply it. So the BB&J agreement. Remember I mentioned earlier that it's very, oh, maybe I didn't, that it takes a long time to write a treaty. So this timeline goes back to 2002 and shows the different steps on the way through various UN processes and various negotiating stages. And in fact, the text was adopted in June of this year and opened for signature in September. We're looking for entry into force in 2025, so after more than 20 years of preparation. The objective of this treaty, which is called the High Seas Biodiversity Treaty or the High Seas Treaty or the Biodiversity Beyond National Jurisdiction Agreement or the BB&J Agreement, take your pick, is to ensure the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction, all that light blue that was on the map I showed earlier, for the present and in the long term through effective implementation of the relevant provisions of the Law of the Sea Convention and further international cooperation and coordination. That is a critical element that this treaty can provide. So it covers these areas beyond national jurisdiction, all that light blue area, from seabed to sky. Actors are subject to the agreement if they're under the jurisdiction and control of a state party, for example, the source of government funding, where a company is incorporated, or where a ship is registered. It provides a forum and mechanisms for multilateral cooperation on ocean governance. It allows governments to collaborate through the Conference of the Parties and other treaty bodies. It should also facilitate communication and planning between treaty regimes that regulate particular industrial sectors. So this could be helpful for CDR because it can help unify some of these diverse regimes. It offers a contribution to equity by building capacity to engage in the science and governance and financing to support that capacity building. It requires consultation at various stages of the activities. It provides transparency. The environmental impact assessment provisions would apply, for instance, if a CDR project is going to affect that part of the ocean or take place in that part of the ocean, it would be screened to see whether or not the activity might cause substantial pollution or significant and harmful changes to the marine environment. And if that appears it would, then you would do a full environmental impact assessment with public consultation. The ultimate decision on whether or not to proceed remains with the state or states that have jurisdiction and control. And it provides for protecting valuable and sensitive ecosystems using area-based management tools and long-term fully protected marine protected areas. Those can be flexible tools to manage climate intervention research and deployment in particular areas. So how will it apply? Well, over 80 states signed in the first few days. It was open for signature in September. It takes 60 to actually ratify it. And so that's very promising. And maybe I'll end on this note that states can begin right now to start implementing the provisions, but normally it would go through this process of adoption of the language, signature of the treaty. That's all happened, and the U.S. has signed. Then it would go through national legislation to ratify it. Some states don't need that, and some states, when they accept the treaty, it will immediately come into effect. In the U.S., you would need national legislation, and then implementation through the various kinds of authorities. So for that, the next step is to move forward on that treaty and then put wholehearted effort into the coordination and cooperation. Thanks.
Thank you very much, Cymie, for that. And we will now move to Korey's intervention.
Thanks very much, Will, and thank you, Cymie. I think this is a nice transition. So I'm going to stay in the ocean space, but now I'm going to turn to domestic law instead of looking at international law. All right. Let's see. Can you see my screen? Great. Okay. So as I said, my talk is going to focus on domestic U.S. law. And what I'm going to look at is laws governing ocean CDR research in U.S. waters. And so the position that I'm arguing here is that it's essential that we have an effective governance framework that facilitates needed research while also ensuring that it occurs in a safe and responsible way that minimizes risks to the environment and to communities. And although progress is being made on this front, we don't currently have that framework. I'm going to suggest some actions that the U.S. federal, regional, and state governments can take to improve the governance of ocean CDR research. All right, so a variety of ocean CDR approaches have been proposed. They range from growing seaweed to store carbon and sinking that seaweed in the deep sea, to adding alkaline rock to ocean waters to facilitate greater carbon uptake. Many of these approaches appear to hold promise, but they require further testing and evaluation to better understand how they work and better understand their risks and benefits. In many cases, the next step in research for these approaches is in ocean field trials, and that can bring risks. But we need to test these things in the ocean to verify that they will actually be effective in removing and durably storing carbon dioxide, and that they won't have unacceptable adverse impacts on the marine environment or communities. We're already seeing some large investments in research from governments around the world. In August, the Department of Energy announced that it would provide $1.4 million in funding for 8 projects aimed at developing novel ocean CDR techniques. And earlier this year, the Department of Energy announced $45 million in funding for research into ocean CDR monitoring, reporting, and verification. The NOAA National Oceanographic Partnership Program will provide an additional $24 million for research into ocean CDR. Other governments around the world are similarly investing in this type of research, including several EU-funded projects and one funded by the Chinese government. Alongside this governmental funding, we're seeing quite a bit of private sector investment in ocean CDR, and that includes a number of US-based startups that have been established with the goal of developing and ultimately commercializing ocean CDR technologies. In April, one of these companies Ebb Carbon announced that it had raised $20 million in Series A funding. There's been a focus on the policies that are needed to support this industry, but the legal framework in which it operates has been comparatively less focused on and given comparatively less attention. That's an issue because the legal considerations could have a major bearing on where, when, and whether this ocean CDR research occurs. So there's a huge amount of legal uncertainty and complexity surrounding this ocean CDR, which is not conducive to facilitating safe and responsible research. Part of the reason there's so much legal uncertainty and complexity is that we're talking about activities taking place on the ocean, which is a shared resource. Excuse me. There's a large body of international law that governs ocean-based activities. We got a great overview of that from Cymie. And many of these laws, especially in the US, are implemented through domestic law, as she stated at the end there. Generally speaking, under international law, countries that border the ocean have primary jurisdiction over waters within 200 nautical miles of their shore. And in the US, jurisdiction of this 200 nautical mile region is shared among federal states, tribes, coastal states and territories, and sometimes localities within those states and territories. There is at each level of government multiple agencies involved in managing ocean resources and overseeing ocean-based activities. And you see here a map of US ocean waters and where they're located in the ocean. At the Sabin Center, we've looked at the treatment of different ocean CDR techniques under existing US law. We've primarily focused on federal law, but we've also done some work on state law. And we published a series of white papers that you see here that look at how these laws apply to different ocean CDR techniques, including ocean alkalinity enhancement, ocean fertilization, artificial upwelling and downwelling, and seaweed cultivation. The key finding across all of those papers is that in the US, there's no current single comprehensive legal framework specific to ocean CDR. But there is a large body of general environmental law that could apply to ocean CDR. And these general laws were developed to regulate other activities and might not always be a good fit for ocean CDR, which again creates this complexity and uncertainty for projects. Ocean CDR projects may, depending on where they occur and the specific activities involved, be subject to multiple overlapping and sometimes even duplicative permit and other legal requirements. So this slide gives you an indication of just how complex the situation is. And I want to show you quickly this table, which is taken from the 2022 National Academy's report on ocean carbon removal that my colleague Romany Webb co-authored. And this table, you don't have to like memorize this or anything to understand my talk, but it shows the key federal environmental laws that could apply to ocean CDR techniques. And it notes that this is a non-exhaustive list, so I don't think we claim to capture the entire field. But even so, as you see, there's a large number of potentially applicable laws. And this is just federal laws, and some projects might be subject to state, local, and tribal law in addition to everything you see here. So this situation is far from optimal. Navigating this legal framework with potentially overlapping and duplicative requirements at the federal, state, and local levels is likely to be very difficult for researchers. The cost, time, and complexity involved with complying with these legal requirements could hinder or entirely prevent needed research. At the same time, our research shows that gaps in existing legal frameworks mean that they might not effectively protect environment or communities. For example, we found that certain activities in certain locations are unregulated, which could create opportunities for rogue actors to pursue projects that are not scientifically sound or present unacceptable risks. And if this happens, it could derail legitimate scientific projects from going forward. So now turning to possible solutions, and there's different options available at every level of government, but if we start with the federal government, and at the executive level, the Ocean Climate Action Plan released by the Biden administration in March 2023 specifically discussed the need to develop a robust legal framework for ocean CDR research and deployment. Last month, the White House Office of Science and Technology Policy announced a fast track action committee on marine CDR, and the committee will develop an implementation plan over the next year to draft recommendations on permitting and comprehensive federal research. This aims to fulfill one of the recommendations of the Ocean Climate Action Plan. There's a variety of actions that federal agencies can take under existing law to improve the permitting process. At the Sabin Center, we're drafting recommendations to this effect, and we're aiming to publish those recommendations later this year. One of the most impactful things that agencies can currently do is to better coordinate among themselves. And it's important that they coordinate on permitting, on environmental review, and on application processes to remove duplication and streamline the procedure. We're also developing recommendations that specific agencies can take to improve permitting, like clarifying when their statutes apply to ocean CDR activities and when they will treat research different from deployment under those statutes. So absent agency action, we can also see congressional action in this space, or even alongside agency action. There's a variety of different forms that this congressional action can take, but earlier this year, the Sabin Center published model legislation that Congress could enact to create a new dedicated legal framework specifically for ocean CDR research. And the idea here in the model law is to replace the current patchwork of general laws with a single statute that's designed specifically for ocean CDR research. Our goal in drafting it was to define the scope of federal authority over ocean CDR research, establish a regime for permitting research projects, establish requirements for consultation and assessment of environmental risks, and incorporate safeguards to ensure that these risks are managed and that the projects are conducted in a safe and responsible way. This model law was informed by consultations we did with stakeholders, including government representatives, scientists, lawyers, and environmental nonprofits. And those stakeholders inputted both through these workshops, through one-on-ones, and with draft model law reviews. So the key innovation in the model law is to designate a single federal agency with responsibility for overseeing ocean CDR research. Enactment of this model law would eliminate the current fragmented approach and designate a single agency to take charge. That agency would be responsible for, among other things, permitting ocean CDR research projects in ocean waters. While the model law does designate a single lead agency, it emphasizes that that lead agency will need to draw on the expertise of federal agencies, fellow federal agencies, and regional, state, and tribal and local levels. The language on this slide lays out the findings and purposes of the model law, which is section 1 in the model law. And it notes that the federal government has a compelling interest in regulating ocean CDR research. But at the same time, we recognize that tribes, states, and local governments have an important role to play in this space. This slide gives you an idea of how the model law works. Looks pretty complex here, so I'll try to tease out ways in which I think it's not maybe as complex as it looks. The model law creates an interagency working group, so that's what you see at the top here, working on ocean CDR research, and that includes representatives of all the different federal agencies that have an interest in or expertise with respect to ocean CDR. That interagency working group is responsible for developing a national research plan with public input. Then that plan would be sent to regional bodies that would be responsible for developing a strategy to implement the plan within their region. These regional bodies would work with states and tribal representatives to identify locations in the region that are best suited to research. The national research plan and the regional research strategies would then be used by the lead agency to decide whether, when, and where to permit projects. And this would all be done with public input, trying to create an inclusive decision-making process. So that's the basic approach, but we recognize that this isn't the only way forward. It's meant sort of as a facilitative first approach to get the conversation rolling. So the federal government isn't the only institution with authority to act here. As I've mentioned, the ocean is a shared resource, and coastal states, regional bodies, and tribes play an important role here. There's a lot that they can do on their own, even without the federal government, to improve the regulation of ocean CDR research. The options might look different for different states depending on the laws that they have currently, but there are some broad categories of actions that all states can take and should be thinking about. First, with respect to permitting, states can look at the way to streamline their permit application process. In some states, ocean CDR research projects require permits from multiple agencies, state agencies, similar to on the federal level. And they should streamline these processes where they can. They should also, where necessary, clarify the criteria that they will apply in deciding whether to issue permits. The paper on this slide is a look at California's permitting process for seaweed cultivation, and it makes some recommendations to that effect. And in addition to these permitting reforms, states can also look at their existing marine planning processes and evaluate how CDR fits into that. They can think about whether they might identify preferred locations for projects to go forward, and that can really help prevent and manage conflicts for ocean uses. They can improve and streamline environmental review processes and aim to conduct programmatic environmental reviews rather than having to review each project individually. And finally, they can play a key role in engaging and educating stakeholders, including the public, about ocean CDR. And this is important to help build the social license to enable research to happen. All right, so this last slide is just a sort of a plug for our website if you want to learn more and read the papers that I pointed out, and also feel free to email me directly with questions. I'll stop there.
All right, thank you so much, Korey. And we will now move on to Ben's intervention. Ben?
Great. Yeah, thank you again, Will, for having me on. And it's been great to hear from the co-panelists so far. I've appreciated the deep dive into ocean carbon removal. And I think one thing that's come through in those presentations is the complexity when we're talking about the regulatory environment for any one CDR pathway, and a reminder too of how nuanced it gets, that when we're talking about MCDR itself is not monolithic, and there's multiple marine pathways. So I'll share my screen and wanted to walk through a couple of slides. The perspective I wanted to bring was to zoom out a little bit, which I think complements the more in-depth look on MCDR, and just talk about what it means overall to create a safe and enabling regulatory environment across a real broad suite of carbon removal pathways. So I'll walk through a couple of slides, and just to start, and as a quick introduction, I'm the executive director of the Carbon Business Council. We're a nonprofit trade association representing more than 100 carbon management companies, which combined represent more than 6.5 billion in combined assets, and really have a focus on how we scale up and reach gigaton scale carbon removal. We'll put a link in here to a newsletter we put out every 2 weeks, the Carbon Fix, in case folks are interested in following along the latest of what's happening with policies, what's happening in the startup innovation ecosystem, and the rest. So just a little bit on us and the vantage point that I'm bringing as we talk about regulations. I think one thing to start with is the legislation that's passed that can create some of the regulatory impetus and the backbone to help further scale on the R&D side or the commercialization side for carbon removal. So won't go into too much depth on all of this, but just wanted to give some context and have the slide up briefly that shows us a little bit how we got to where we are today. A lot of what we're seeing coming out when we see DOE's recent procurement program for carbon removal, the $35 million program, came about as a result of congressional appropriation from a year ago. When we're talking about the DACUPs and we see that announcement came out, that came about as a result of the Bipartisan Infrastructure Act. So just, again, this quick refresher on the different legislation that's out there that has helped to scale up carbon removal, has helped create an enabling environment for which companies can start to enter the ecosystem and work on building up to gigaton scale carbon removal. So happy to go during Q&A into any more depth about some of the different legislation that's been introduced, passed, adopted, and where we're at with that. And then and again, I think the legislation that's passed on the Hill federally or at the state level can directly speak to how do we make sure that there's regulatory frameworks that can follow suit in an executive branch. One of the biggest highlights that I would call out as we think about creating this safe and rigorous and strong regulatory environment, and a regulatory environment that closes some of the gaps that we heard being talked about in some different carbon removal pathways, is how do we have the same starting line and a level playing field for multiple forms of carbon removal to scale? The idea behind this level playing field is, what do we need to do to incentivize innovation, and how do we encourage private sector capital? And I think what I'd put out here is that if we created a robust regulatory framework for only one form of carbon removal, or only two forms of carbon removal, that in turn risks having a stagnation effect on the private sector capital in the market. So how do we make sure that when we're talking about the suite of different carbon removal approaches that are very varied and require different sets of permitting, how do we make sure that these are all moving forward, again, in tandem and at the same time, to create that level playing field and to have that innovation, is something that we spend a lot of time thinking about at the Carbon Business Council. That is not necessarily one regulation that will do it for everything, but that we do want these regulations to be moving forward and keeping in lockstep with one another. One thought that we have on this is that it partly starts with a definitional sense of, when we're talking about the regulations and an enabling regulatory environment for carbon removal, that it starts with the definition of, what does it mean when we talk about carbon removal? What is carbon removal and what's not carbon removal? Earlier this year, the Carbon Business Council convened a working group. We published an issue brief on defining carbon removal. That one conclusion in the issue brief was to call for a method neutral and criteria based approach for carbon removal, so that carbon removal should not necessarily be defined squarely as any one pathway. There's emergent pathways, there's a suite of pathways, but really getting into an agreed set of criteria for what it means when we're talking about CDR. And the issue brief goes into challenges, opportunities, and recommendations for that. And happy to share around a link to anyone that wants to take a deeper dive. When we're talking about it, and we have this sense of what we're talking about for carbon removal in a unique set of pathways, there are challenges to remain method neutral. And one that I would call out in particular, because it's moving in the near term, is the European carbon removal certification framework. So outside of the US, what's moving forward in the EU, earlier versions of this had been more method neutral, more encompassing of multiple carbon removal pathways. But in the most recent update of it that's come out and had an initial vote, the CRCF more narrowly defines carbon removal as only geologic storage. And so that the implication of that is it's leaving out enhanced rock weathering, biochar, marine carbon removal pathways, anything where there's not geologic storage. And if we start to define policies in those ways, or have regulatory regimes in those ways that start to box out certain pathways, again, it creates that not level playing field. In this case, the Carbon Business Council wasn't the only org that thought so, or was pointing out the challenge. I believe was last month, joined 16 other organizations making a call for the CRCF to remain more method neutral. And the letter's online if anyone wants to take a look and see the case we were making about why, and the particular advantages of keeping this more method neutral approach. I think CRCF provides one example of something that policies being passed with regulatory pathways that are not creating that level playing field. But if we look at the US side of the equation, we've recently been seeing a slew of pathways in the US that do speak to a more level playing field and that are method neutral. The Carbon Negative Shot Initiative, run out of the US Department of Energy, is taking a tech neutral approach and encompassing of multiple carbon removal pathways with a shared goal to reach $100 a ton or less to remove carbon from the atmosphere. And so the Carbon Negative Shot I'd call out as an example. DOE, the Energy Department, announced when the DAC hubs were announced that there would be carbon negative shot pilots coming soon. So we should expect to see a funding notice, a funding opportunity coming out for those soon. And based on the carbon negative shot framework, are anticipating that call for funding will be along a more method neutral line. And we also saw this happen with DOE's recent procurement announcement. When that came out, the $35 million that DOE is allocating for procurement, if you look at the eligibility and the criteria, multiple carbon removal pathways included within that instead of only one. So a couple of examples when we're talking about different policy incentives and regulatory landscapes in the US that are moving forward with this call, have multiple forms of carbon removal scale rather than a smaller subset of them. Just to continue on a little bit with the U.S. snapshot, I think what I wanted to call out here, and again, this touches on what some of the prior panelists have been speaking to, there's not one agency that where their domain for carbon removal permitting sits under. It's multiple because of how multifaceted carbon removal is. We're seeing a lot of different headway and a lot of different U.S. departments and agencies and globally to create enabling and regulatory environment for carbon removal. So the US EPA fairly recently put out a really detailed tracker of all of the different Class 6 permits that are under review. That tracker is on the website. Put a link of it here. It's small to see, but I think just a great example to show both the momentum of how many folks are trying to move forward on Class 6 wells for underground storage. But it's not the only one. OSTP recently announced a fast track committee on marine carbon removal. There's an open call for input right now on the idea for geologic sequestration on public lands for the US federal government. And so really different departments are actively working to tackle this in different ways. And it speaks to taking this method neutral approach and trying to make sure that multiple forms of carbon removal are scaling in suit, again, rather than having one complete regulatory framework and having others where there's a lack of guidance or information. And so it's been encouraging to see these different pathways scaling up along the process. One other thing that I want to call out, and this is shifting gears a little bit, is that when we think about permitting and what it takes to achieve a permit, as different permits are coming into existence, whether they're existing like a Class 6 permit or new permits that are being in the process of being created, having community buy-in and the social license to operate is a really critical part of the permitting. There's the legal language of what's in a permit and the checklist of what you have to follow. Typically, permits require and mandate a certain level of community engagement. And to obtain a permit, you ideally want community stewards and communities who are on board rather than communities who might be advocating against a climate tech project to argue against it. And I think on this end, I just, for purpose of discussion, and maybe during the Q&A, if folks have any additional questions or thoughts around this, wanted to introduce in that as we're talking about creating an enabling regulatory environment and permitting pathways, the other side of that coin is how do we talk about creating an environment where carbon removal has the social license to scale and operate? To this end, I wanted to flag an initiative that the Carbon Business Council recently released. We were fortunate to benefit from expertise and input from the Institute for Carbon Removal and Policy on this effort. CDR-RDT is an online training, introductory concepts about community engagement and the pathway for engaging with communities, and introductory resources about what these community engagement pathways look like. It's obviously an entire domain and complicated subject matter. And so this online training is a first step rather than being inclusive of it. But I think in the context of talking about permitting and regulatory environments and the legalese language, just wanted to also plug here how integrally related the social license for scaling carbon removal is closely tied to that. And just as I wrap up here and we continue on with other panelists and then go over to questions from you all, I'm excited to hear what folks that have tuned in are thinking about this. I think the one thing that I wanted to call out is we've just continued to see record-breaking growth in the private sector around carbon removal. There's been billions of dollars that have been allocated. The circular carbon economy has more than 5.77 billion in capital raised. When we look, CDR FYI tracks carbon removal sales, and when we look at sales at this time this year compared to this time last year, the sale of carbon removal credits has gone up by more than 400%. I attribute a lot of this private sector investment to an enabling public sector environment. Having the policy incentives that exist or the regulatory pathways has really helped to unlock and free up private sector capital. And I think as we look ahead to 2024, 2025 and beyond, thinking through, again, how we have this level playing field and an enabling environment that will let carbon removal go through the R&D it needs to, the commercialization it needs to, will just be critical to continue ensuring that private sector capital is there to match that ambition and be aligned with the IPCC's targets of the gigatons of carbon removal that we need in tandem with the significant cuts to emissions reductions we need. So with that, I will thank you again to the Institute for Carbon Removal and Policy for organizing this terrific conference today. It's been great to hear from all of the other speakers, and I will turn it back to Will.
Great. Thank you so much for that, Ben. And we are going to move on to our final speaker. But before that, I'd like to remind everybody to start populating the Q&A box. And after Christian's intervention, we will move on to audience questions. And so I will turn it over to you now, Christian.
Okay, so you can see the slides in presenter mode rather than any notes. Okay, great. Let me, before I start here, get the window with the video out of the way. Okay, thank you very much. So the background of my talk here are 2 research projects on assessing CDR and policies to govern CDR. And the presentation is also based on Antonia's work, who is doing her PhD in the POET project. The other acronym that you see here, ASMASIS, this is a project that is on assessing marine CDR. So somewhat obviously, for proper governance, we need information on opportunities and risks of different CDR options and on barriers and enablers to develop proposals like those we have just heard about in the previous talks. And one important tool to provide that information are assessment frameworks. And several working groups have been or are developing frameworks for assessing and for comparing CDR options. And many of these frameworks follow the general approach outlined in the IPCC special report on the 1.5 degrees C goal. We think, however, that this approach has a serious conceptual flaw. So let's have a brief look at the report. Its stated aim is to assess the feasibility of limiting warming to 1.5 degrees C and the feasibility of mitigation and adaptation options in 6 dimensions. And these are geophysical, environmental, ecological, technological, economic, sociocultural, and institutional. And these dimensions are supposed to cover a broad range of possibly relevant issues that go beyond geophysical or technological aspects. And this is partly in response to limitations of previous feasibility studies that did not consider important barriers to implementation, such as law, public acceptance, and other political and social and institutional factors. So it makes a lot of sense to broaden this approach, but however, the way the IPCC introduced and developed that results in the incorporation of normative criteria. So for illustrative purposes, let's look at the sociocultural dimension, reading what conditions could support transformation in behavior and lifestyles, and to what extent are the transformations socially acceptable and consistent with equity. So this also seems to be about what is just or what's equitable. But the framework fails to discuss how these normative issues are related to the assessment of the feasibility. So are these normative issues, are they boundary conditions within which feasibility is tested, or do they affect what is feasible by influencing what people, so policymakers, citizens, are willing to accept and willing to do? Or is the framework actually broadened beyond feasibility? And from the report, that is not really clear. So then 4 years later, the 6th assessment report of the IPCC was published, and the framework was further developed and used, and you would expect that also this issue then is clarified or somehow developed. But that is actually not the case. So to cut a somewhat longer story short, the general view here seems to be that equity and other issues are important aspects within different dimensions. So here in chapter 1 from working group 3, authors say that some fundamental criteria may span across several dimensions. Most obviously, issues of ethics and equity are intrinsic to the economic, socio-cultural, and institutional dimension. But that perpetuates rather than clarifies the criticized ambiguity, because again, it's not clear how these issues are actually related. And again, chapter 1, this time from working group 2, says that the solution is feasible to the extent it is considered possible and desirable. And then AR6 assesses the feasibility of a wide range of adaptation options, building on the 1.5 degree assessment report framework, which uses 6 dimensions of feasibility. So, but what is desirable is different from, so let me start again. So here saying, as they do in the quote, saying that feasibility is determined by what is possible and desirable does not make much sense, because what's desirable is different from what is feasible. It's not a subcategory of feasibility. And what is possible is simply another word for, can be used to describe what is feasible. So overall then, and again, kind of I'm moving here too quickly. So these quotes are also in contrast to what the how the AR6 own understanding of feasibility, because in the glossary we find the definition that feasibility refers to the potential for a mitigation or an adaptation option to be implemented. So this is about the potential or possibility to implement something, which kind of is, I think, very close to a common sense use of the word, and it's also in line with the academic literature, for example, on political feasibility, that is about the likelihood of implementation if one tries to actually implement the option. So it's about the likelihood of the possibility to implement an option. So again, kind of how the descriptive issue of what is possible or feasible, how these issues are related to the normative issues about what is good or desirable, remain entirely open in the IPCC feasibility framework. And we believe that this is a problem because subsuming normative issues under feasibility, as the IPCC proposes it, disguises value judgments and results then in misguided policy recommendations. We think that instead, these assessment frameworks should be built on the distinction between feasibility, so what can be done, and desirability, and by that we mean what would be good to do according to shared values. And to also make transparent how these two issues are related and the values on which the assessment then of the desirability is based. And to you that may sound very much obvious. To us it's somewhat obvious, but to our surprise, not only does a large number of studies draw on the IPCC framework and adapt it for particularly fields and questions, including notably CDR, but they kind of, with very few exceptions, these studies also remain silent on how feasibility and desirability are related. So these conceptual flaw kind of is then repeated and partially even kind of taken further by these follow-up studies. And another point in case here is the GESAMP report that assesses different marine geoengineering options. This report is not based on the IPCC approach, but also remains vague whether it assesses only feasibility or feasibility and desirability and how these are related. So we think the upshot is that this results in a situation where most current frameworks mix descriptive feasibility and prescriptive desirability consideration in an intransparent fashion. I think we all agree that this is not what we want to do. We want to be transparent and we want to be clear whether or not we are talking here about values and which. And kind of more kind of practical societal problem is we believe that this forestalls the necessary discussion about, for example, how to shift boundaries of feasibility as to enable the implementation of what we think is desirable, and kind of to discuss what actually we think is desirable, because that's quite important to be, explicit that we say this kind of a certain option or a certain pathway, we don't think that's good, instead of cloaking this in the language of saying, this is not feasible. which is often happening also in climate negotiations and in academic and public debates. So that's our critique here, and kind of building on that, we are developing alternative approaches. And kind of in the last minute, I'm going to briefly present you our proposal for assessing policies that govern CDR. So here, the object of assessment are policy instruments, and not the options, but rather the policies that incentivize or regulate or de-incentivize CDR, depending obviously on the policy. And because we're talking here about policies, we think it makes sense to generally distinguish two areas of this assessment. One is about the adoption, implementation, evaluation, and refinement of the policies. The other is about the impacts of the policy. Obviously, kind of these can also should be related. We kind of implement certain policies based on our expectation of its impacts. And also when we have information about the impacts, this hopefully then informs the refinement of the policy, if there is one. And then kind of what we're currently doing, and what Antonia in particular is doing, is to propose a limited yet comprehensive list of criteria for assessing carbon CDR policies. And kind of this list of criteria is based on a comprehensive literature survey on criteria for policy assessment. And we think that all these criteria can be grouped into 6 overarching assessment categories. So again, when we're looking into the top of the picture here, the kind of adoption implementation of the policies, we have 2 categories. One is about feasibility, the other about procedural fairness. So on the one hand, we want to know, can we implement the policy? This is then about political feasibility, administrative feasibility, possibly financial feasibility. But we also care about, how will this policy, or is it implemented? Is it implemented fairly? And beyond that, we have 4 kind of general impact categories. Obviously, we want to know whether the policies are effective in reaching their goal. Here, kind of the goal would be to remove carbon from the atmosphere and store it safely on a long-term basis. Ideally, this is done at least cost, so it is so the input-output ratio is good or even optimal. Policies will have all kinds of distributive effects, so it will affect humans in all kinds of direct and indirect ways, and all this is supposed to be captured by the equity criterion. And then lastly, we have a category that's called environmental ethics, kind of somewhat weird term. This is kind of because many people, including us, believe that it's not only humans who have moral entitlements to be treated in certain ways. And so this environmental ethics category contains a number of non-anthropocentric criteria. And then to just briefly wrap this up, there are a number of assessment criteria that you can see here. I do not go into them. We also kind of have second thoughts regarding the environmental ethics criteria, but kind of from this large, kind of huge table of kind of potential possibly relevant criteria, we kind of condense this into and systemize this into this overview here. Then of course it would be relevant, well, how do you use this framework? But that would be another talk here. I mainly wanted to highlight that there is a need for different kinds of frameworks, and how our proposal roughly looks like. The main distinction that I mentioned earlier, you see here that certain criteria assess the feasibility of the policy, and then a bunch of other criteria that assess kind of whether the policies have impacts we are in a way that we consider to be desirable according to values. And and environmental impacts kind of affect a number of different criteria in the equity and environmental ethics dimension. And with this, I stop and thank you for your attention.
All right. Okay. Thank you so much, Christian, for that. And we are now going to move on to the question stage. And Just thought I'd ask a couple to seed things, and then we'll move on to audience questions. An initial question for Cymie when we're talking about BB&J. Obviously, one of the issues as BB&J comes into force, assuming it comes into force this quickly, is how its mandates would interact with mandates of other international regimes that have already asserted some jurisdiction over marine-based CDR, or may, cotton to do so in the future. How do you think? How does BB&J contemplate playing well with others in the oceans on these issues?
Yeah, that was a really central question in the negotiations, not specifically with respect to climate intervention technologies, but with everything else like fishing, and especially fishing, where there's a lot of well-developed treaty regimes. So there's provisions that in the treaty text that on the one hand say that the treaty activities shouldn't undermine other regimes, but also that ask the parties to the BB&J agreement, when they're acting within these other regimes, to apply the BB&J approaches. So the easiest one to talk about probably is the environmental impact assessment measures. And we might compare those with, say, the London Protocol assessment measures. I'm not actually I'm deeply familiar with the BB&J, but not with London Protocol assessment. But, you'd sit down and you'd look and see, well, are they overlapping? Are they similar? I always think of it in terms of a U.S. federal government interagency committee kind of process, or a co-lead on U.S. National Environmental Policy Act environmental assessment, that there's ways that these things get worked out so that you get the best result and you get something that's efficient, hopefully, and also reasonably comprehensive and satisfies all the standards. Does that answer the question?
Yeah. I think it's going to be an interesting process going forward. But yeah, that's great. So one other question for Christian. I know that you said it was beyond kind of the purview of this study to determine who might engage in this assessment process. But I'll put you on the spot at this point and ask you who you think should do it, right? At this point in time, where we're largely relying on the voluntary carbon market, right, to police itself when it comes to CDR. Is it likely that these kind of criteria would be employed in that kind of environment, or is it going to be critical in terms of capturing some of the considerations that you outline here to have a government role? And if there's a government role, does that have to be international, or can it be national?
Yeah, I think your question, who should use it, is much easier to answer than who might actually use it. So I think who should use it, academics, governments, both. I mean, the framework is in a way somewhat generic. It's not, you can use it for at the international, at the national, even local level. So I would, so as far as I'm concerned, but if I'm obviously kind of an academic philosopher and others from that perspective, I would say it would be ideal if kind of governments, regulatory bodies, and also businesses use that. But I think it's most useful for those who actually are concerned with the regulation of CDR, that would be kind of public actors, and those also who discuss these issues with them and also criticize them, so NGOs and other civil society organizations. So it seems to me that for the latter and also for academics, that might be most useful. Others might use parts of that framework. I mean, government representatives told me if they design policies, they don't look for equity issues. Yeah, so obviously and I'm pretty sure they also don't consider very much how this affects non-human beings. I mean, they may be concerned about this by what they think how this might impact the public, but not directly by concern for I don't know, beings in the deep ocean. Although then again, it may also totally depend on who's in power and on the party. So in Germany, for example, in a couple of regulatory bodies, if that are closer to the Green Party, they have clearly more sympathies to these ideas than others. So the short answer, I think. So realistically, I think it's not that these kind of people scream out loudly. They have just waited for this framework. It's clearly it will not be the case, but I hope that at least some academics, for some NGOs, for some interested governmental bodies or some people in that might help them to, let's say, at least structure the debate a bit and, simplify that complex field a little bit, or at least make clear what actually the norms and values, or what the role of the norms and values we all have and then implicitly endorse could be in shaping our thinking about, or our opinion about these different options.
Great, thanks for that. Question from the audience. There's some, and I guess this is for Korey. There's some debate as to whether ocean-based carbon removal fits within the definition of sequestration in the regulations. For the sale of credits, do you know who does the validation of carbon credits?
Yeah, so I think maybe Ben could weigh in here as well, in terms of how 45Q applies, because that isn't like a specific focus of our research, but it is true that a number of these private companies that are going out and doing ocean CDR research are seeking to finance their operations by the sale of carbon removal credits. And often those are being validated by private parties. I don't have like specific information about ebb carbon, which the questioner might be asking about there. But yeah, that sort of like unregulated private verification of these systems, I think maybe raises some concerns with folks about, uniformity across different approaches, that sort of lack of governmental clear regulatory space.
Yeah, anything to add on that, Ben?
Yeah, I think it's a great question, and it touches on, I guess, the three key letters in carbon removal of MRV: the monitoring, reporting, and verification of removals. And I think across the board, whether we're talking about marine carbon removal, direct air capture, enhanced rock weathering, this question of MRV, how do we get the receipts and know that a ton is a ton for carbon removal to be taken away, is a critical part of the conversation. In a similar way, in my remarks that I was talking about permitting frameworks being different for each carbon removal pathway, MRV does look different as well for the different MRV pathways, but some really important work is happening right now related to MRV in the oceans, and we're seeing a lot of movement in the space, I think, both on the private sector side and the government side. I think the fact that we see marine carbon removal included in the Energy Department's procurement program, that for the MRV of that, it implies that there's conditions and criteria there within the prize to think through what that MRV looks like. And we see different companies in the MCDR space coming out with updated protocols and MRV standards. So I think definitely a space to watch. It's relevant for MCDR and for all of carbon removal in its entirety, how the conversations around MRV progress.
Okay. Another question for you, Ben. One of the things that you emphasized in your presentation was the role of public engagement, right, on these approaches. And public engagement seems to have been problematic recently with some projects, right? There's some discussion of concern already in terms of the direct air capture hubs in places like Houston, that at least some elements of the public feel like it's not being done in a way that's particularly helpful. Do you think that's intrinsic to public apprehension about CDR per se, or are there things that we're not doing that we need to do in terms of structuring public engagement protocols moving forward? And if it's the latter, what else do you think we need to be doing that we're not doing to get this right?
Yeah, it's a great question. I'm happy to answer it. Before I do, I saw, Cymie, that you had your hand up, so I'm not sure if you want to touch back on a prior question before I answer Will's.
Go ahead, Ben.
Okay, sounds good. I I do think that we're seeing a challenge here across the board, not only with carbon removal, but with climate infrastructure projects more generally, about how can there be community acceptance to break ground. And so there's, I think, tenets and lessons and extrapolations we can make for carbon removal, but a offshore wind project in New York was recently denied a permit, and the local community was concerned about it. And there's a stat that sticks with me, that research has shown that only 13% of renewable energy projects with local opposition are completed after they face an initial or delay. And I can drop in the link of where that came from in a Science Direct study. But I think it just shows how high the stakes are, that if you end up with strong community stewards to support a project, it can help streamline the project and make it move forward. And if you end up with strong opposition, whether you're talking about an offshore wind project or a solar project or a carbon removal project, it can become more challenging to be able to obtain permits and move forward on that project in a community. So there's a whole lot to unpack there. I think in the context of permitting, this idea of social license surfacing feels definitely relevant to the conversation, which is why I wanted to bring it in. There's a lot of different ways to unpack it. I'd call out that new resource, that carbon removal responsible deployment training that I mentioned, of introductory resources, and community benefit agreements are another element to this. And so I would also call out, because Korey's on with the Sabin Center, that the Sabin Center recently released a great best practices guide for community benefit agreements, and some studies there. So I think if folks are thinking about permits, it's great to think about social license, and there's a whole lot of resources to unpack on that front.
Yeah. Cymie, sorry I missed you before.
That's okay. No, this is a great actual lead in, because I was reacting to the Christian's comments about public engagement, and I thought you might find it interesting that the BB&J agreement, an international treaty for areas out way the hell out, also has included consultation, some specific references to the engagement of traditional knowledge, local and indigenous communities. And so you kind of scratch your head and think, how do you do that? What's that mean? I don't have an answer to that, but it's part of the treaty. So it's part of the commitment to figure this out. And the kinds of issues that Ben's talking about, I think are, they're really important. The other piece was that I've been looking at public engagement with Gene Drive, and so similar kinds of problems. And I think this is true for CDR too. These guidelines that so many are putting forward to say, oh, this could be a guideline for researchers, are so science oriented, so focused on the scientific community as who engages. It's like government and scientists. And there is very little contemplation or understanding of who else might be a stakeholder. So stakeholder analysis seems critical, and modes of public engagement seem crucial and not figured out.
Yeah, I think that's a good point. And I think the CDR community probably needs to turn more to lessons learned in some of these other contexts of some of these high return, potentially viewed as high risk sort of approaches, and what's worked and what hasn't worked, right? Yeah, Gene Drive seems like a quintessential example, and I agree with you. It's going to be fascinating to identifying who the stakeholders are, right? In a lot of these sort of projects, right? It's potentially the entire world, I guess, right? With an interest in the global commons, right? But that's going to make it a pretty unwieldy process. But yeah, I guess we'll see. So another question. This is for Ben. how is CDR factoring in ESG considerations for by corporate entities and investment firms?
Yeah, that's a great question. I think something that we're seeing with ESG right now is I think different corporates are taking different approaches for how ESG is defined in their portfolio. I think broadly for corporates who are going the direction that within the environmental criteria for that E, if they're thinking along the lines of a net zero pledge or even a net negative pledge, that's where carbon removal so quickly enters into the equation. That if a company is trying to balance out emissions and get to zero, that's where carbon removal enters the equation. And then there's a whole lot more to unpack there about the particular pathways with which a company might approach it. One thing that the Carbon Business Council has been advocating for is the concept of twin targets in a net zero pledge, so that there's specificity about the amount of emissions reductions taking place and specificity about how much removals is taking place. The Standards-Based Targets Initiative in terms of one guidepost has suggested that net zero pledges might be 90% reductions and 10% removals. And so I think it highlights this point that in the context of removals, and I know the focus of our panel and the focus today is on removals and what are we talking about with permits and what are we talking about to scale the market. But I think when we zoom out and are thinking about, okay, how are we actually achieving net zero, we're reminded that it's one part of the equation, but the majority of that equation continues to be on the emissions reduction side. So I think we're mainly seeing it play out within the net zero context, but I think there's additional opportunities on ESG for corporates to be thinking through what are the co-benefits for communities that carbon removal can present, and the whole gamut of how this structures into corporate portfolios and climate pledges.
Okay, thanks for that. All right, I'm going to accord all of you one final opportunity to make final comments and takeaways. Right? Are there important messages when we think about emerging legal issues for the CDR community that you'd like to convey at this point? I'll start with Cymie.
I'm sorry, something just happened in the background. Can you repeat the question, please, Will?
Yeah, just any final remarks you have about what the implications are of going forward of BB&J in the CDR community?
I think this is a great time to have lots more of this kind of discussion. I particularly appreciated this invitation to open some conversations, and would invite people who are interested in thinking this through to, get in touch with me, with others who are working on getting the BB&J convention into force and implemented, because in the next couple of years, there's going to be a lot of preparatory work in setting up the institutions and the procedures. So having those conversations now will help shape what the actual implementation looks like.
Yeah, I think that's really an important point. In my opinion, one of the shortfalls of the Marine CDR corporate community has not been engaging enough with these regimes. I mean, maybe hoping that they wouldn't have an impact on their operations. I don't know what the reasons are, but I don't think it behooves them. And this is a great opportunity to get in on the ground floor as something is organically developing, right? And help message what that community thinks is important, and maybe help shape policies that both optimize protection of other interests and also help facilitate CDR, right? So I encourage people that are on this call that are in that community to think about engaging with Cymie and others that are working on this, because this is going to be a regime with a lot of power in the conference of the parties, and so it is going to be organic, right? And so there's an opportunity to really communicate what you think is important that community may not know about when it comes to these approaches. Okay, Korey.
Yeah, I think I have a really similar takeaway to Cymie here, in that we intended our model law as sort of an opening salvo like a laying out of what we thought sort of our ideal vision of how the structure of how the US federal government could regulate ocean CDR research. And that was informed obviously by quite a few stakeholder and other engagements with folks in the space, but there's no way that you can cover the entire space in those conversations, in those like preemptive conversations. So if other folks have, ideas of how to structure this governance, then I would like highly recommend it. It's a really like interesting, creative exercise to try to foresee a governance regime. And if you have those thoughts and you can add that to the conversation, I think that will help tease out the complexities, maybe, some of the failings or weaknesses of our model law, and can lead to a more cohesive whole. So yeah, if folks have thoughts on that or research projects, and then, there's, as I stated in my presentation, as we often talk about, it's not just federal reforms, there's huge area for tribal input here. There's laws that could happen state to state across the entire country. So the same sort of structure governance thinking could happen at the state level as well.
Yeah, thanks for that. I think it's really laudable what Sabin's done in this context, because you're right. There's probably lots of other aspects that need to be incorporated, but it at least creates a framework for that discussion, and that's going to be really important if we're going to scale any of these things tenably. Ben?
Yeah, it's been great to hear from the panelists so far, and thank you again, Will, for organizing the panel today and the whole conference. I think that one thing that I would highlight that I do think was coming up on the nuance of what each of the co-panelists was speaking to, just how intricate it gets when we talk about a permitting framework for any one form of carbon removal, but then to zoom out and be reminded that we are looking at carbon removal in the aggregate and the whole. And so as we're talking about a framework or permits, we might be talking about drilling in and talking about one pathway, whether that's Class 6 permit or talking about the regimes for what MCDR is needed. But if we can think about creating this level playing field so that multiple pathways for carbon removal have an opportunity to scale, and that we can keep private sector capital flowing in, I think that's going to be a really interesting issue to watch as we're thinking about 2024, 2025, and just beyond. How do we continue to keep innovation flowing and private capital flowing by having permitting frameworks follow suit and keeping pace with one another rather than to have some breakaways?
Yeah, I think that's a good point. It's going to happen in parallel, and we don't have a lot of luxury for lag time. And finally, Christian.
Thanks. Yeah, as I'm not really a legal expert, I take the liberty to take up the question in the chat from Q&A from Sarah, asking about stakeholders and rights holders. I mean, I would, from my perspective, I would say that kind of all stakeholders also have rights, and kind of if we think at least of individuals, kind of we are all affected by climate change, probably in one way or another, and so we're all in a way also our rights are possibly minimally, but kind of are also concerned by CDR. But then again, kind of we have moral rights, we have legal rights, and kind of these kind of different moral rights and different legal rights, and will often not be on the same page. And therefore, I think a kind of also normative analysis from legal scholars based on legal theory, and kind of same for the moral norms and rights, actually is very important to not, and I guess that might be behind Sarah's comment, really highlighting that there are some people that are directly or indirectly affected by CDR, whether we do it or not do it, kind of could also be, potential victims of climate change who do have a stake, that this stake might be quite strong of a different nature than the stake of, I don't know, kind of to use a simplistic example, a company that wants to increase its revenues or whatever. So and therefore I think it's important to keep that in mind, and also to analyze it properly, and also to kind of not be too shy to also, make comments on these values, which many of my science colleagues want to stay away from, understandably.
Yeah, I think that's a good final takeaway. So I want to thank all of you for excellent discussion and excellent audience questions. And with that, we will end this panel. and then we will be back in about 2 minutes for our final panel of the day, which is a roundtable discussion that'll look at the potential role of hard regulatory mandates to try to facilitate substantial scaling of CDR and the feasibility of these approaches. One under a U.S. federal law, and the other more broadly denominated a carbon take-back obligation that could be applied at the national level or the state level in various jurisdictions. So please come back for that in a couple of minutes. And with that, I'll say thank you very much.